to the White House. There's been a public adjudication of that ground. Similarly, with all the other examples you provide, full process has been provided. But what you're saying is, I have a right, and judicially created, we're going to say there is no process whatsoever you're entitled to. Now you're saying you're entitled to what Congress permits. The question is, what's that?
In this context, that's not even Mandel, that we don't have to give a reason at all if this is the reason for the denial. But I would say that we don't think that there's a separate category of liberty interest for getting information as opposed to the underlying liberty interest. And so the fact that she wants to live with her husband in the United States doesn't mean that she has a liberty interest in having information related to something that prevents him from doing that. And I would also say that
she would need to exercise her right to live with him on the ground that you don't have a statutory basis to exclude him.
But she doesn't have a constitutional right to participate in that proceeding and say you got this decision wrong. And that is not unusual, that there are instances where nobody is able to. As Justice Kennedy's concurring opinion pointed out, we give the examples of the prisoner who is not able to challenge a transfer to a different prison, the soldier who is not able to challenge a military deployment. In Castle Rock, where the court relied on O'Bannon, that was an instance where nobody was able to get enforcement of that that restraining order.
You're not mentioning independent constitutional rights. All right, thank you, counsel.
Justice Kagan?
I think I just want to understand the conversation that you had with Justice Alito before about the nature of the constitutional interest here versus in Mandel. Judicial review, in other words, this legitimate and bona fide state explanation. In the case where there is a constitutional right implicated, as there was in Mandel, and the question that I thought I heard Justice Alito asking was, if you assume that, why would this constitutional right be less important than the constitutional right that was implicated in Mandel? In other words, the right of a few professors to listen to some guy for a few hours, why would that be more important than the right of a person to be able to live with their spouse in this country? And are you saying that it is? Or are you saying that once we think of Mandel in that way, yes, this constitutional right is just as important?
Yeah, I don't think that we've tried to compare the constitutional rights in that regard. I think that we would say that Mandel hasn't decided
you would not contest that this constitutional right is any different.
I would suggest that there could be a difference between First Amendment rights and the Due Process Clause and the third-party interests that are at stake in the due process analysis under O'Bannon. But as I said to Justice Alito, I still don't think that that means that a spouse could come in and have a better claim because they want to talk in person with their spouse instead of, over the telephone.
Right. Well, she wouldn't need a better claim if you were willing to say, yes, the right of marriage and the burden that this places on that right is just as important as the right of listening to, a lecturer that was at issue in Mandel.
And I think my basic answer to that, Justice Kagan, is the assumption of your question, which is that we think that Mandel didn't actually decide that, which is why it's open for the court to decide the first QP here. If it wants to assume that there's a liberty sort of and therefore gave a very limited form of review, then you'd be doing Mandel analysis, and we think that we would win.
Okay, thank you.
Justice Gorsuch?
One level, this is a very large case about fundamental liberty interests. At another level, I wonder if it's a small case. We talked about remedies a little bit a moment ago, you and I, and I'm just curious, what remedy does the plaintiff seek here? I know they wanted originally a declaration that there wasn't a bona fide reason, seeming to take Mandel as given. I'm looking at page 13 of in their complaint. But they got that. They got that reason. They got the Mandel reason. Then they want a declaration that the statute's unconstitutionally vague. That's not before us. Then they want their costs. That's not before us. But if a district court the husband into the country, what other relief remains that's available for a court to issue?
We don't think there is any. I think that they've asked for declaratory judgment that the reason that was given was not good enough. I think that now they would say that if this court says that the Ninth Circuit is wrong about what we did give, then they would be entitled to more, I guess, is what they would be saying on remand.
How about this, that the declaratory judgment would be you got the Mandel reason, because that's what the Ninth Circuit found. It just wasn't timely, period.
Well, the court didn't grant review on the third QP. We think that the timeliness analysis is wrong, and we think it's particularly odd to say that this lawsuit needs to trundle on.
Would the government oppose a declaratory judgment that it wasn't timely in its Mandel statement?
Well,
and what?
So untimely. The Ninth Circuit it was provided, and I understand my friend to be asking for more information even now.
But you wouldn't know if the court's correct in the Ninth Circuit that they got all the information they were due, at least at the Mandel stage, and the Ninth Circuit's remanding to pierce that to conduct some sort of due process analysis about whether it was good enough. What could the Ninth Circuit or district court do at the end of that proceeding that would be lawful?
We don't think anything, but I don't think that's a reason to affirm what the Ninth Circuit said here. I think that would be a reason to reverse and say that this case is over.
Counsel, I'm not fighting you. I'm just asking some questions.
Yeah, and I agree with you that I don't know I don't think there is anything that the court ought to be able to do on remand.
Yeah, thank you.
Justice Kavanaugh? Justice Barrett?
Essentially be asking us to Justice Scalia's position in DIN. Based on some of your colloquies with my colleagues today, I'm thinking that maybe what the government's first order position is, and I had not gotten this from the brief, I thought you just mentioned it in a footnote, is to say that Mandel should never have assumed that there was an exception if there was a fundamental right implicated. Is that right?
Well, I think that the point of Justice Scalia's plurality opinion in DIN would be that there wouldn't be an exception to consular non-reviewability that applied anyway. So I think it would get there one way or the other.
No, I agree, but it's different. I mean, I think Justice Kagan called it a much more dramatic holding. It would be different. I guess I see you potentially asking us to do one of two things. One would be to say there's no fundamental right here. She doesn't have a fundamental right in having her spouse live with her in the United States. To say, and by the way, people shouldn't have an opportunity. There's a fundamental right implicated, because after all, Mandel had just assumed that. It didn't say that you are entitled to get a Mandel explanation if you can point to the existence of a fundamental right.
That's right, and I was saying, for purposes of the assumption in Justice Kagan's question, that if we assume that there is a constitutional liberty interest that is sufficient to trigger that review in Mandel, why isn't this one equally good?
Right.
And our position is that this is not, as the plurality concluded in Kerry against Din, not a sufficient liberty interest to trigger any exception to consular non-reviewability that would look like Mandel review. So we think you don't get to Mandel review one way or the other.
No, and I understand that, but I guess, and I'm still not quite sure what your position is. I understand that. I'm just asking you, are you asking us to say, to go still further than that and say, and but we think there's no such exception at all. So Are you asking us to do that?
I don't think you need to do that. I think the question presented is based on the idea that there is the background of constitutional unreviewability, and the exception is not triggered here for that reason.
Okay, that is what I understood you to be asking from your brief, and I thought you were asking for more in the course of the argument. Okay, this goes to Justice Gorsuch's questions about what might happen, and this is something that I'll ask to the other side as well. But what do you understand the further process to be? Because it doesn't do someone all that much good, just was. You know, as Justice Sotomayor was saying, if you think my husband is John Doe, but he's actually Jack Smith and has no ties to MS-13, the value of that information would be to have some opportunity to be heard about why it's wrong. But Mandel really is just about notice, and none of the court's cases, which really just kind of understanding to go back to the department, go back to the consular official, is the idea that the district court to hear why this is wrong and why the tattoos didn't really show an MS-13 affiliation.
They might contemplate that that's what they would be getting because they want the information that is what he said or what he did. We don't think that that's appropriate. I think that if the court were to say that so I'm not sure what they think is going to happen with respect to that. They could refile a new application with the State Department. If they have this information, they will know this was the reason for the first denial. But that doesn't mean that the point of Mandel isn't actually notice. It's confirmation that the government had a reason. And so I'm still fighting the premise that the point of Mandel is to provide the person who is complaining with did our procedures within the State Department decision. Anytime that there's a denial, that has to be reviewed by a supervisor. This particular basis for inadmissibility needs to be based on an advisory opinion from Washington, D.C. And so there are lots of other ways in which the State Department can be asked to go back and improve this decision. We don't think that that should be done at the behest of judicial review and a court saying, you have to do this and I want to see all of your evidence.
Okay, so the government's position is that even if Mandel applies, once you point to a reason, whatever is required to make that reason sufficient, that would be kind of the end of it anyway.
Yes, as Justice Gorsuch was just quoting from the prayer for relief in the complaint, it would be a declaration that that's not a good enough reason.
And then you go on your way, and if you want to try to go back to the State Department.
If they want to refile, since they're past the time for reconsideration, was before the agency at the time, and it might come out differently the next time.
But would there be some process in the State Department for letting them make their case that these tattoos, for example, didn't actually show an affiliation with MS-13? Or is it just like you file for reconsideration and the State Department says, okay, well, that wasn't good enough, but we still think, and maybe just add a little bit more? I
mean, they did provide that information to the State Department.
Right.
The officers looked at that information and concluded that it didn't change their answer.
I understand that, and they weren't satisfied.
Yeah.
Okay, thank you.
Justice Jackson?
So I'm a little trying to understand the government's argument about fundamental rights and the way in which Mandel works. In your colloquy with Justice Barrett, I think you said that there is not a fundamental right to have her spouse live with her in the United States. First question, am I wrong about that?
I'd phrase it slightly different, that there's no liberty into the United States, notwithstanding immigration law restrictions. So, yes, she has a liberty interest in living in the United States and in living with her spouse, but we don't think that is a liberty interest that allows her to overcome immigration.
No, I understand that, but I'm just trying to see how your argument maps onto what the court actually did in Mandel. And as I read that case, as I look at it, the first thing they're asking is whether these professors had some sort of right to receive information and ideas as protected under the First Amendment. They weren't saying, at the level that you're saying now, do they have a right to have this particular person, or do they have a liberty interest in having this individual come to the United States as their first question? It looks as though right to receive information and ideas, and he goes on. He gets to the point that you're talking about when he says recognition that First Amendment rights are implicated, however, is not dispositive of our inquiry. And then he goes on to do the rest of the inquiry. So I think the parallel structure here would be the recognition that there is, as we've said in so many cases, a fundamental right to marriage, to include cohabitation, to raising your family. Those things exist, and that's implicated by the government's decision not to allow a person to come in, the spouse to come into the United States, and then you go on to determine whether or not, even though you have this right that's implicated, the other aspects of the test. What's wrong with thinking about it that way? Because I hear you shifting the fundamental right at the beginning.
So the court is looking for liberty or property interests that by
all right, and
the government. Bannon tells us that the fact that it is directed at a third party is a distinction for due process purposes, and so we
there
think
was
that
no underlying interest in O'Bannon. I mean, didn't we say there was no right to live in the nursing home of your choice, whereas we have recognized the fundamental right to marriage and raising a family and that kind of thing. So I think O'Bannon might be a little bit off in that way.
Yeah, but I mean, I don't think that analysis carries the day here, because the court would never apply that analysis for purposes of the removal proceeding or any of the other proceedings here. The court would not say that she has a due process right to participate in her husband's removal proceeding because it might take him out of the country. And so the fact that there is this long tradition non-citizens will be admitted into the country, we think creates a high bar here,
so
and that there needs to be a specific. I don't think that it's a liberty interest that's just in getting information or an explanation. We think it would be a liberty interest in actually having him in the United States.
So is it your position that there isn't a liberty interest in, it has to be more specific than the liberty interest in cohabitation with your spouse to begin with, that would then trigger some sort of due process in this situation, and whether or not the government is satisfied that is another question?
Yes, ultimately the point here is that being able to live with your spouse in the United States is not the same thing as being able to get your spouse admitted to the United States.
Okay. Thank you.
Thank you, counsel. Mr. Lee?
And may it please the court. Over 8 years ago, the government violated Sandra Munoz's right to procedural due process by denying her husband's visa without providing a reason why. Ms. Munoz has a constitutional liberty interest in living with her husband. We do not claim that this interest gives her the right to immigrate her husband regardless of his inadmissibility. But the importance of cohabitation to marriage means that the government is required to provide procedural protections when it burdens the underlying right. The statute also informs there's nothing unusual about this. When government action burdens a substantive right, the court often relies on procedural protections to balance the implications of that burden against the government's countervailing interest. The statute likewise here shows why Ms. Munoz was herself deprived of that liberty interest and application from start to finish, and the very American citizen spouse. Given this interest, judicial review is required. This court has repeatedly acknowledged that the constitutional rights of U.S. citizens can be implicated by visa denials, and when they are, that review is necessary. Procedural due process, therefore, requires notice sufficient to allow a meaningful opportunity to respond. A mere citation to a broad statute that encompasses any other unlawful activity forced Ms. Munoz to guess at the reason for the denial and provided only a mere gesture at due process, which this court said was insufficient in Mullane. The information Ms. Munoz ultimately learned came after the one-year deadline to respond had passed and after the government had informed them that its inadmissibility finding was permanent. And I welcome the court's questions.
Mr. Lee, I know others may want to the interest in Den. And I can't think of any decision from this court that said that such a liberty interest actually exists. Would you give your best account of how you get to this liberty interest?
Yes, so there is a liberty interest in marital cohabitation which arises under the Constitution. This is something which the court has addressed in multiple occasions in the past. In Loving against Virginia, for example, cohabitation was at the very heart of that case. That was a couple that was married in Washington, D.C., and the anti-miscegenation statute in the Commonwealth of Virginia prohibited them from living together as man and wife. The state court of appeals there said that... I
understand that. That's a different case. What I'm interested in is we had this exact issue in Den. Exactly what about. But we did not get a court for that. And this immigrate to this country has been considered. That's what I'm interested in.
I see. To clarify, that's not the procedural due process right that we're advancing. We do not claim that Ms. Munoz has a right to do what she wants, live with her husband in the U.S., even if her husband is inadmissible. We're merely asking for a reasonable and workable solution, which is that some basis for the denial be given so that we can correct the possibility that there was a mistake. And so
I'm interested in the liberty interest that requires the procedural right, the underlying liberty interest that we could not find in Den. That's all I'm interested in.
I see. And in a number of the other substantive due process cases, Meyer, for example, which acknowledged the substantive right to raise a family and establish a really personal, intimate association was recognized against the court acknowledged, even without any statutory hook, that a non-citizen had the right to bring his wife to the country, even though she did not herself possess a certificate which was required at the time. So we think
none of those address the central issue, which is the consular non-reviewability. Which sort of seems to me to be an entirely different order of magnitude than the cases that you've cited.
So, Your Honor, on the doctrine of consular non-reviewability, the government raises this as an exception when the rights of citizens are implicated. If a case where a U.S. citizen had been living with her husband for 5 years and that they had tried to go through the legal process and the denial was given without any reason of the basis why, that's the type of case that has previously considered the merits of particular professionals. That's at 2416 of the opinion. We do not think that the court would be breaking any new ground by acknowledging that there is no doctrine of consular non-reviewability as applied to the implicated liberty interests of U.S. citizens, especially without...
What more would you be entitled to than what you've gotten? I understand the question of the timeliness of the elaboration, but what else do you think you're entitled to?
What we received, what the Ninth Circuit said was sufficient, is far better than any other unlawful activity. And so to answer your Honor's question...
But as you said, what you've received.
That's correct. After that one-year deadline had passed, that's at 22 CFR 48...
So you think you're entitled to more just because the deadline had passed?
No, but with enough information so that we're not trying to fight back with our hands tied behind our backs.
In court, then you say reasonable opportunity to contest, so you can force the government to provide more evidence behind the reasoning, or what happens?
Well, no, Your Honor. What we think is the way what we think is the most appropriate way to proceed would be to take what the Department of Homeland Security applies in the domestic context, which is a general level factual summary of the basis for the denial, excluding material that is sensitive for national security purposes. What that would do is it would mean I don't think any party in this case wanted 8 years of litigation. A rule like that would allow these cases to be determined at the agency level.
Counsel, you got that. I mean, the Ninth Circuit said that's exactly what you got. So why are we here?
Because what we're asking...
Either. I'm with Justice Alito on that. Maybe you can help me. But it seems from the prayer for relief, you've got every
back to the and try to overcome the denial with the information that we now have.
So you're not asking for further judicial process?
That's correct, Your Honor.
Okay. So Mr. Gannon suggested you can go ahead and file a new application.
And the problem with that is that at page 16 of the joint appendix, the government informed my clients that its false determination of Mr. Asensio Cordero's inadmissibility was permanent. So I do not think that without an order from a court saying that the basis for that denial was insufficient.
So you want a declaratory judgment that it was insufficient?
I don't think that there's a way around that, Your Honor, because otherwise we're going to be fighting an impossible battle of trying to disprove that Mr. Asensio Cordero, or rather trying to say that he is no longer a gang member when that would require
the government. You can't reapply, and I'd like
that came only 3 years after the denial and 2 years into litigation. And so my clients reasonably understood that the determination of inadmissibility became permanent. I believe it was in May of 2016. We still had 7 months in the 1-year deadline, which the government says is in the regulations is an individual has the opportunity to overcome the denial, but that's meaningless, and it puts people in a Kafkaesque situation if the regulations say, well, sure, you have the opportunity to overcome the denial, but we're not going to tell you why.
What do you do with Mandel and Trump versus Hawaii and Justice Kennedy's concurrence in Kerry versus Dinn, which suggested that entitled to, and it's up to Congress if they want to provide more elaborate
colloquy, my friend, previously there was discussion on some of the language differences.
Sorry to interrupt. All three cases suggest that a facially legitimate bona fide reason's enough, and you stop there and you don't go on, and that was elaborated on in Trump versus Hawaii. That's it. Courts will neither look behind the exercise of that discretion nor test it by balancing its justification against the asserted constitutional interest. That's kind of it.
So
for purposes of judicial.
Right, and so I can get to some of the distinctions with Dinn and Justice Kennedy's concurrence, but I want to say first that the court has applied that facially legitimate and bona fide test in two types of situations, unlike the situation here. The first is a discretionary ability to deny So it's operating peaks of plenary power, but the amicus brief from the congressman, which was submitted, says at page 23 that the department's position is that this decision should have been left to one political branch, the executive. The point I'm driving at, Your Honor, is that the Congress here has required that consular officers have a reason to believe an individual is inadmissible. The regulations refer to that as a standard which is akin to probable cause. So we think under a Matthews-Eldridge analysis, the risk of arbitrary deprivations and along with the...
Well, it seems to me that's what you're trying to do, is replace Mandel and the Justice Kennedy concurrence and Trump versus Hawaii with a Matthews v. Eldridge test, which would then in turn, as you would apply it, require...
Well, don't get me wrong. We think we can prevail under the facially legitimate and bona fide test as well. And if I can turn... For one, there was a factual basis in that case on the record, the fact that Ms. Din's husband was working for the Afghan government when the Taliban was in power. There was reference earlier to 1182b3, which the government treats as a broad non-disclosure provision. That is not the position that they took in Din against Kerry, where they said at page 50 and 51 of their merits brief that when the executive does disclose additional material, that reflects a considered determination that the information provided does not require invoking the protections of 1182b3. They did not invoke 1182b3 now at the time of the denial, and so we think that that militates for at least
way the interest in
lets on. Regulations which security applies in the domestic context to the same exact statutory framework, the same grounds of inadmissibility. 8 CFR 103.2 says that an applicant shall be advised of the facts leading to the denial.
I guess I do mean to interrupt. I mean, it's you say in the domestic context. That's kind of a pretty dramatic premise if you're going to say, well, it's the same as it's going to be in the domestic context. The whole point of consular non-reviewability is that it's not in the domestic context.
Well, but by the same token, Your Honor, it wouldn't make sense if these due process regulations apply in the domestic context to non-citizens, but they don't apply submitted by former DHS officials. Reasonable, workable proposal, and they cite this provision, which I just like to own behalf before the decision is rendered.
Well, counsel,
that seems to,
I'm sorry, Chief.
that seems to be flatly contrary to what, the quote from Justice Frankfurter, which I don't remember, is that that's something that's been in the body politic from the very beginning, that the United States has control over its borders with respect to non-citizens who seek to come in.
But not, Your Honor, when the rights of a U.S. citizen are implicated. And the position that the government has put is that she's been permanently separated from the man that she loves for 8 years without having any basis, any chance when there was an opportunity to respond under the regulations to try and convince them that they made a mistake.
Just to pause just very briefly, she's not been permanently separated from the man that she loves.
Your Honor, because the government cannot dilute an American citizen's citizenship by forcing them to Americans not to travel there. Born and raised in this country, she has a successful law practice here. Her father served in the U.S. Army in World War II in Germany.
Lee, I guess I want you to assume a few things for me, and some of the assumptions you'll like and some of the assumptions you won't like. But I just want you to assume them, and then I'll ask my questions. So assume that you get Mandel review because you have a constitutionally protected liberty interest in cohabiting with a spouse. Assume that that review is limited and asks only for a bona fide and legitimate reason. Assume that the information that you got eventually, not in a timely way, but eventually, get it in time, as I understand the issue. So if I think that the simple statement, he was an MS-13 member, is sufficient under Mandel, but you didn't get it in time to invoke the reconsideration process to say, no, you got that wrong, he wasn't an MS-13 member, what do we do now?
Then I think the court would have to remand so that the individual could have an opportunity to try and prove to the consulate that they may have made a mistake. And there's a big, big difference between any other unlawful activity.
You're saying that what we should do now, given that the information that satisfies Mandel was untimely, is essentially to tell everybody they should be put back in the box they were in before that information became
The relief you seek is the opportunity motion for reconsideration at the consulate.
Incorrect.
If that's the case, I don't see that in your complaint, number one. And number two, what do we do with Judge Lee's observation that as a practical matter, it appears your client understood before the motion for reconsideration deadline passed that was indeed the basis of the government's denial, that she understood that the gang membership in MS-13 was the hang-up. Now, you didn't know all the details, but you did understand that fact, and if that fact alone sufficed to provide the Mandel notice, is this harmless error?
No, and let me try and take the second part of Your Honor's question first. We actually, Ms. Munoz and Mr. Asensio Cordero did not guess correctly. The government said were merely the suspicion which triggered the inquiry. So there was no correct guess of the factual basis for the denial.
Is exactly what the government thought, too.
But even there's a very significant difference between gang membership, there are hundreds of these gangs, and the specific gang that they ultimately provided 3 years later. Now, I'll be very concrete with how we would have done this differently if we'd have even known that bit of information. And a brief aside to say that I think if there was...
Does Mandel require the specificity of the particular gang that he was affiliated with? Wouldn't it be enough for the government to say he's affiliated with an international gang that conducts violence and drug trafficking operations, for example?
It wouldn't be enough if there was additional facts that did not implicate based on a criminal review.
Let's just
then yes, that would be the end of the
end of the case. That would be harmless error then.
But there
No, but think
convicted or charged of any crime.
I understand that. I appreciate that fact. But if your client understood that gang membership was the problem, and if the government said gang membership, if that were enough to satisfy Mandel, why doesn't it follow that any error here is harmless?
Well, to clarify, and I don't want to put too fine a point on it, but that would only be enough if if you're talking about such a significant fin indicating what gang he may belong to is not, it would implicate national security. In almost all cases, there's going to be facts that can... I don't know whether it would
implicate national security. I'm positing it.
Point about what we would have done differently, because had we known MS sentences in passing, it uses MS-13 as an example. It makes no attempt to actually analyze how these tattoos might have been related to that gang. I am not a gang expert, but when we go back on remand, we will be able to provide, this is Our Lady of Guadalupe, a tattoo of Sigmund Freud.
You know, I mean, that was interesting.
Maybe
Counsel,
MS-13 doesn't like psychoanalysts.
Justice Gorsuch's question here. I mean, Mandel doesn't require that much. And so you are, and this kind of goes to what Justice Kavanaugh was asking, you are asking for significantly more. If we think you don't get that much more under Mandel, I guess I don't see why Justice Gorsuch isn't right that this is just game over.
Well, let me. That concurrence, and I'm operating under the assumption that we're working with Mandel here, that concurrence specified at
the premise of his question was not just that you knew the general statute. I understand you think that's not enough. But he said if you knew further that it was because of international gang membership in an international gang that conducts violence and would likely conduct violence in the United States, why isn't that enough? That's different than just the statutory citation.
Because in almost all of these cases, Your Honor, there's going to be factual information, like DHS tells individuals in the domestic context, that can be provided without damaging national security. So, for example, the State Department lists in its Foreign Affairs Manual the 10 factors that officers are supposed to consider. Whether they...
Mr. Question by referring. It's a constitutional question, and his question would present a danger when they states. How do we weigh that? If respondent's husband were a citizen, it wouldn't matter whether he was a member of MS-13 or any other gang or whatever the government's him of being involved in criminal activities. She could live with him unless he were in prison, right? So it's an absolute, it's a very, very extensive right. Now, you're translating it into the situation where it's the opportunity to come here. How do we figure out how much she gets?
That decision separating in this case, as the court knows, it was this very broad language. It was I will concede.
Well, you say there's a balancing, and you've got on one side a right that would be very, very weighty were they both U.S. citizens living in the United States. And then you're willing to dilute it so that it's only this big when the person wants to come into the United States.
And I think the court has addressed a similar context in the prison-type cases, Vitek against Jones, Harper against Washington, where the court recognized an underlying substantive constitutional interest, for example, in not being forced to take psychotropic drugs or not being removed to a mental facility, and yet the way it balanced those interests was by providing a minimal level of procedural due process. Have very heavy caseloads. They're working under very difficult conditions. And what we're asking for is for them
if I could follow up. What if an American citizen wants to have a child who is a non-citizen admitted to the United States? Would the same thing apply there? Or an American citizen wants to have a non-citizen parent admitted? Or an American citizen who doesn't believe in marriage wants to have a non-citizen admitted to the United States so that person can live in an intimate relationship with that person in the United States? What about all those situations?
So the only person that's going to have both and I want to take a half step back in answering that and try and define the interest precisely as well. The only person who's going to have an interest directly deprived is going to be a spouse. You have to have both an underlying liberty interest, which we get from the Constitution, and you have to have a direct no statutory role to play whatsoever in the certification process, et cetera. But so along on this, but citizens can only petition immediate relatives, and citizens have to be adults to petition immediate relatives. So so all those other floodgates concerns are exaggerated because the only person who's going to both be statutorily involved enough to have been directly deprived and have an underlying liberty interest in marital cohabitation.
Well, do those people have a liberty interest? And if they do, then how can it be deprived by statute? How can it be taken away by statute?
So, for example, a grandparent and a grandchild, they certainly would have an underlying liberty interest. That's from the Moore case. But they wouldn't be able to petition each other. So my point is that you have to have both these elements. And that's going to be my answer to all the floodgates concerns that Your Honor posits, because you need to both, and there is no
to contest the denial of a visa for a close relative or a person with whom the person has a close relationship who's not an American citizen.
Well, this is a case about marriage, Your Honor, and this is a case about the importance of marriage, and this court has recognized this. Congress for over 200 years has recognized this, even in the immigration context. 1804 was the first time immigration benefits passed through citizenship. 1888, at the peak of Chinese exclusion, Congress passed the Scott Act, which exempted Chinese laborers who had wives in the United States.
And Mr. Lee, I guess what I'm not seeing, to me, there's no weighing at issue here. The way I understand the analysis working is that if you come forward or certainly whether it's the right to associate with your spouse who is that in cohabiting or associating with a person who is not getting a visa, that gets you something, but it doesn't get you weighing. It gets you this very limited judicial review, which says the government now has to say why it's excluding that person. So that's all it gets you. It's just like you come forward with a right, we don't weigh that right. It just gives you the ability to force the government to say one or two sentences about why they're excluding that person. So what weighing are we talking about?
No, I think Your Honor put it better than I did. I mean, we have here a very important constitutional interest. It would certainly not make sense if Mr. Asensio Cordero could ask a professor to get his
okay, you got what you wanted. You got the information that they were brings us back to Justice Gorsuch's questions about why isn't this whole thing over because you got what you wanted?
Because now, for the first time, we're going to have the opportunity to go back and harness the facts that's necessary to try and prove the government wrong. We don't have the right to win on remand. We'll go back to the consulate. We'll do our very best. There is a lot of information that we can do with the reasons that were ultimately given. Doesn't give us any guarantee, but that's what due process requires.
But Mandel, and this is just a question about the constitutional argument, this is kind of goes back to the questions I was asking before. Mandel talks about notice and giving you the basis, but it doesn't talk about Mullane and an opportunity to be heard. And your weighing, I take it's probably coming from Matthews versus Eldridge, which I don't think is the standard. Mandel context.
Well, there was a broad discretionary grant. We think that that's a foundational difference. This is a discretionary decision which Congress has established. Officers must have this reason to believe. We think that that does a lot to get us to where we need to be, Your Honor.
Thank you, counsel. I understood you to indicate that what you thought the relief you were seeking was just limited judicial review. Is that right? Or exactly what is the relief you're seeking?
We do not need any additional judicial review here, Your Honor. I think on remand this will go quickly to the consulate so that we can finally respond to the information that we've been given.
And how do you come to the fact or the conclusion that that is what you're entitled to when you're discussing the right of a married couple to have one of them come in across the border? How do you get to the determination that but you, I don't want to give it away, when you look at the United States, what you'd conclude is that you get this limited judicial review.
I see. Yes, going forward.
And you do that by doing what?
Well, we do that by requiring that there is, we've had some discussion as to whether the facially legitimate and bona fide test applies or whether something slightly more strenuous applies.
I don't care what the test is. What is it that the tests entail?
The test is entailed at determining that the government did not make a decision which either has no basis in reality or which was violative of the rights of a U.S. citizen. And so
does it involve weighing the interest, the marriage interest and the international interest?
Well, I think there's another government interest, which is in uniting American citizens with their spouses.
Does it involve the weighing of that interest as well?
Well, we don't see it that way, Your Honor. We see it as we have to provide sufficient low level of information. It's what DHS does domestically. Well, we do not see it as a sort of explicit balancing issue. We see it as
my point is that if you're going to take two competing interests and come to a conclusion about how the competition comes out, I don't see how you can avoid the conclusion that involves weighing what I at least see as totally disparate and perhaps unweighable interests.
Well, but I don't mean to be hard-headed, Your Honor, but that's what this either facially legitimate and bona fide test or the slightly higher standard that we're asking for gets us. Because, again, we are certainly solicitous of the government's concern in keeping individuals who are inadmissible out of the United States, but individuals who are admissible should be admitted to the United States.
Well, I beat it a little bit. Now, there are a number of possible answers. Suppose there's a liberty. The State Department says, we believe he's involved in criminal activity. B, we believe he's a member of a gang. C, we believe he's a member of a particular gang. D, we believe he's a member of MS-13. E, this is why we believe that he's a member of MS-13. F, if I'm getting my numbers straight, we believe that, and you have an opportunity to rebut it. Now, how do we determine which of those is what you get unless we're weighing one thing against another?
By looking to what the Department of Homeland Security does domestically. And that's what those...
Okay, thanks. It doesn't tell me anything about what the Constitution requires. One final question. Where does cause of action come from? Is it an ex parte Young cause of action?
This issue hasn't been an issue below, so... That's correct.
It's not ex parte Young?
It arises from the Due Process Clause.
It's not APA?
We raised an APA claim below. If the court wants to remand on that issue, they may, but we think it's this constitutional case, Your Honor.
Okay, thank you.
Justice Sotomayor?
There are some of my colleagues who believe that the Constitution doesn't, on its face, provide a cause of action. We have a legion of cases suggesting that, and many of my colleagues taking that position. If they believe that, does ex parte Young help you?
Your Honor, I am not prepared to discuss ex parte Young because this did not come up below. We think that our cause of action arises under the Constitution. We think it comes from 702 of the APA as well, which provides a different route, but...
Justice Kavanaugh?
So just to follow up on, I think, Justice Alito's questions and others, if versus Din and also in Trump versus Hawaii, that requires a facially legitimate basis and a bona fide factual basis. right? Facially legitimate and bona fide.
That's the test.
And then the question becomes, what does that entail, I think? And Justice Kennedy says a number of things about that in Kerry versus Dinn. The government's citation of 1182A3B also indicates it relied on a bona fide factual basis and is also facially legitimate. This is on page 105. Then he says, Mandel instructs us not to look behind the government's exclusion for additional factual details beyond what its express reliance. To a refrains from requiring it to do so, says Congress evaluated the benefits and burdens here and assigned discretion to the executive, and then concludes, I think, with the closer here that's problematic for you. Respect for the political branch's broad power over the creation and administration of the immigration system extends to determinations of how much information the government is obliged to disclose about a consular officer's denial of a visa to an alien abroad. So you put all that together, I think that's very problematic for you if we follow that. And that, in turn, was explicating what Mandel.
And with case, there was the Taliban fact. The government had there invoked B3. The plaintiffs in that case were required to make an as-applied substantive challenge to that statute. We don't have to do so here. But the main distinction, if I understand the line Your Honor is questioning, is the statutory text. And here I want to make a couple of points about the terrorism bar, because not only does this draw a line around a distinct finite range of activity that the officer must have found to have existed to have a reasonable reason to believe, also there's language in there defining a terrorist organization, language defining terrorist activity, an intent requirement. And so we think that that's a lot more.
That's your big distinction, but they wanted a modification there, and he said, in that opinion, the government was not required to point to a more specific provision, even though the statutory provision the council distinction between that case and this case. Give a brief response.
Sure. The critical phrase in Justice Kennedy's analysis of the statute is that it contained discrete factual predicates. Any other unlawful activity is the text of this statute. There is no way to read that statute to have a discrete factual predicate.
Thank you.
Thank you.
Justice Barrett? No. Justice Jackson?
So you're not here petitioning this court for any orders related to future hearings or anything else, right?
Correct.
I mean, you got the reasons in this case, but I thought we were here because it's the government's argument that they shouldn't have had to have given them, given the fact that Ms. Muñoz, in the government's view, has no liberty interest and therefore no procedural due process rights. And those are the questions that we would be answering, not anything about how
Correct. All we're asking for is the chance.
You're the respondent. The government is petitioned, and if we did nothing, you'd be fine, right? Because you didn't want us to take this case.
Correct.
All right. So let me ask you, do we need to roll back or change the doctrine of consular non-reviewability in order for you to win in this case?
No, I think that the court's position in Trump against Hawaii gets us where we need to be on that.
Why is that? Say a little bit.
Because the doctrine of consular non-reviewability does not apply to American citizens. The executive branch cannot restrict review without a statutory provision granting it the ability to strip review. This is not a case where Congress has gone anywhere near that. The citations which the government pulls up in its brief have do not.
So we have never applied the doctrine of consular non-reviewability in the context of an American citizen?
The court has always reviewed the
disagree with you on that. Let's say we disagree. The doctrine of consular non-reviewability applies, but it appears from Mandel that we have recognized an exception to it. Is that how you understand at least the government's secondary argument in this case?
It's a pretty important exception from the standpoint of separation of powers, but yes, Your Honor.
All right, so we're into Mandel even if there is the doctrine of non-reviewability, and so why would you say that you win given the Mandel standard? I mean, they didn't win in that case.
Sorry, Your Honor. Because here, unlike in Mandel, in that case, the professor had violated a prior visa. The court held that there was a factual basis for the Attorney General's denial of a fully discretionary waiver. Here, you have a non-discretionary statute requiring reason to believe there's no factual basis for the denial, and therefore the government hasn't established that the denial was facially legitimate.
Question presented.
If we were to prevail on the second question, no. I do think, honestly, that the court has to reach the first question in order to rule in favor of us.
You think we have to say, we can't just assume it and then, because you can't assume it.
I don't think it would be breaking any new ground to recognize the importance of marriage in this case, though, Your Honor.
Thank you.
Thank you.
Thank you, counsel. Rebuttal, Mr. Gannon?
Thank you, Mr. Chief Justice. If I could just make 3 points. First, I still haven't heard a clear explanation as to why this constitutional right, whether it's a procedural or a substantive one, should be limited to spouses or the effects on visas. My friend said that no one else other than a spouse would have the right to petition under the statute as it currently exists for this type of relief. But if this is a constitutional liberty interest underlying this, I'm not sure why people wouldn't be able to say the inability to make those that type of argument in any other context. Second, my friend talks about the domestic context, talks about what DHS does when there are proceedings in the United States, which have different interests because somebody is here and there is a mechanism for some judicial review there. But it's important to recall here that state is the first line of defense on these issues. And if they deny a visa on the basis of somebody being inadmissible and that person doesn't come here, then there isn't going to be any judicial inquiry. And that person does come here, and DHS wants to remove that person, then the fact that they came here without a visa is an independent ground of inadmissibility, and so they'd be much more likely to be charged with that than the expectation that they would be engaged in unlawful activity while they are here in the United States. And third, if I could get to the colloquy with Justice Gorsuch, my friend talked about this determination of inadmissibility is not waivable. There's not a procedure for getting us to consider whether we're going to make an exception the way DHS had done here on the ground of inadmissibility associated with his previous unlawful presence in the United States. That doesn't say that this is a permanent basis of inadmissibility. He can reapply for a visa and present whatever evidence he wants to persuade us that we were wrong the first time around. But that's not the same thing as saying that there is a judicially overseen rehearing that would allow the court to consider whether our reasons are correct. He said that he wants our inadmissibility finding to be declared incorrect. And so we would disagree that that's what any court should be doing on remand here. The point of Mandel review. Court in Mandel was clear, Justice Kennedy's concurrence in Din was clear, that there's no testing or looking behind the court's decision. And my friend said that in Mandel, the government showed that there was the fact that he had previously violated the terms of previous entries. That was a hotly contested issue in the case. The dissent said that that was a sham and there was no evidence in the record to support it. The majority said, we're not testing or looking behind the government's assertion. This is not about allowing courts to police whether the government's reasoning is correct. The consular officer has to have a reason to believe that this person is inadmissible in order to deny the visa, but that is not judicially reviewable. We urge the court to reverse the judgment of the Ninth Circuit.
Thank you, counsel. The case is submitted. We'll hear argument next in case 23-367, Starbucks Corporation. Ms. Blatt?
Mr. Chief Justice, and may it please the court. Section 10J authorizes district courts to grant preliminary injunctions that they deem just and proper. 10J thus requires district courts to apply the traditional four factors under Section J. All that mattered below was whether any facts supported a non-frivolous legal theory and whether there was harm, not whether that harm was irreparable. The government, a two- or four-part test governs, statutory context compels district courts to conduct, quote, a less exacting and more deferential inquiry into the merits without undertaking an intensive effort to resolve factual issues. But 10J contains no language, much less clear language, diluting the traditional standard. Preliminary injunctions are extraordinary and drastic remedies. Here the board seeks a coercive injunction backed by contempt sanctions, and the board seeks the very same injunctive relief that it would get if it won the case. Such relief is highly inappropriate absent a clear showing under all four factors. The government justifies deference because the board, not trial courts, and how courts should. Indeed, the board in its adjudication the four winter factors. This court has never deferred to an agency's litigation position, and it should not start here. I welcome your questions.
Ms. Blatt, the government says that petitioner's ahistorical, decontextualized approach is inconsistent with the statutory text, the basic premises of equity, and over a century of case law. What's your reaction to that?
No. I don't even know where they're getting that. I mean, this court in Winter and a million other cases have said that these four factors are long of the four factors.
Do you think the government argues that because they are protecting as opposed to the court's jurisdiction, that's a difference?
Not at all. Not at all. I mean, a preliminary injunction, it's assigned to the district court. It has the same reasons. You have to show that there's a likelihood of success on the merits. And obviously, if the harm is recoverable, you're not entitled to the injunction at all in balance of the equities. I don't even understand the board's jurisdiction. There are a multitude of contexts where an agency has an adjudication, and if it wants a preliminary injunction, it's got to make the showing that every other party would have to make.
But this is not just the standard preliminary injunction that district courts do on a daily basis in regular, ordinary cases within their jurisdiction that they control. This is an injunction that is being provided for some consideration of the board's prerogatives. The board is the one that is ultimately making this unfair labor practice determination in the first instance. Congress is setting up a board to take care of these issues. So it's not the ordinary PI that the district courts see, correct?
No, not at all. It is an ordinary preliminary injunction, and this is an ordinary statute with the call to just and proper remedies. And we cite 6 statutes in the U.S. Code that use the just and proper standard, and multitude of statutes say necessary and proper or just proper.
No, I understand, but we are in a particular context. And I think the context has to inform how we understand what Congress intended with respect to this provision of the statute providing for this kind of injunction.
Well, maybe we should just talk about what we're talking about, and that is, does anything in that statute or anything in common sense say the government has not a joke?
But I guess what I'm referring to is that we already have a very different context insofar as the board is assigned by Congress with the requirement or duty to investigate unfair labor practices and make the decision in the first instance as to whether or not they occurred. That doesn't happen in other PI contexts. So I get that in other PI contexts, the district court is doing the fact-finding and all of the things you're talking about. This is a different context.
So on pages 42 and 44 of our brief, we cite SEC, FTC, CPFC, I'm going to run out of the alphabet, EEOC, a bunch of cases where agencies have adjudicatory processes. There's 3 that we cite on pages 23 and 42 where it involves you can go to district court. Why would the board get deference when the board doesn't deserve any deference and has no expertise on how equity should be weighed? And in terms of, we can talk about the 4 factors at my context, like every other injunction takes account of the statutory context. If we were here because there was going to be a nuclear accident, I would think that's an important statutory context too.
You've used in your brief 12 times the description of using the stringent version of the 4-factor test. Is that different than the standard 4-factor test?
This court in the Farmer versus Walsh and Winter said clear showing. So, but yes, I think that is a stringent.
So it's different than the traditional?
Traditional factor test is a clear showing. And what I think.
All right. Now, by success on the merits, which there's some language in some of the court's decisions below that they think they have to, and that's the stuff about not weighing credibility, et cetera. I do understand why that needs to be corrected, because you're right. It's the court that has to decide the likelihood of merits. But with respect to the other 3 prongs, irreparable harm, balance of the equities, public interest, in Winter and Ken, we talked about that there has to be a recognition of the public interest, the Navy's interest in doing what it needs to do. Here, I think it's in the NLRB's interest in making sure that its remedial power both to employer, but the harm to the union and the harm to the NLRB. And finally, the public interest is clear in the board's requirement. So I don't know that either Winter or Ken or anything else, the word deference is just misplaced here.
Well, so we've gotten likelihood of success off the table, but on both the Court of Appeals and the trial court refused to find any facts even on the irreparable harm. So all the board's side of the evidence and only one side of the evidence was considered on irreparable harm. And in terms of irreparable harm, that's something that district courts do day in and day out. And what the board has here and has been arguing in all these cases, and what the Court of Appeals found, is anytime there's an unfair labor practice, if you can show evidence of chill because people in their 10J manual, it's basically a playbook. In every case, they say fill in the blank. They're always saying if there's evidence of chill, if anyone says...
I mean, firing all 8 of the union organizers, I think...
Well, if all
it's hard to see that, although I do understand that some of the organizers did different things than others.
Right.
And the ALJ, who's made factual findings here to whom the court will have to eventually give deference, found that at least 2 of these union representatives should have been fired because they did something more than stay after hours.
Right.
There were employees there who were staying after hours that weren't fired.
Remember, we're here on the injunction. Obviously, the ALJ's findings don't deserve any deference. If there's a final decision by the board and that goes to a court of appeals,
but there were 2 others who didn't union organize that weren't fired.
And 1 union organizer didn't engage in the misconduct and wasn't fired. But here's...
You don't dispute, though, the district court could take that fact that Justice Sotomayor mentioned into account and in the course of weighing whether an injunction is warranted?
Absolutely. I mean, this is a classic case of burden shifting. Was there anti-union animus that justified, that prompted the terminations? And Starbucks managers explained that, and the employees conceded this violated company policy, so the only issue is whether the policy was enforced in other stores.
Pretextual, and a district court could make that determination the way the ALJ did, perhaps.
Exactly. The problem in the circuit split is, and in this case in particular, both the district court and the Court of Appeals said district courts are barred from considering the evidence, and if you count the board's theory, anytime you have an unfair labor practice, that's irreparable harm, and we're just saying no.
But you'd be happy with weighing, right? You'd be happy with weighing the harm to the union organizing against the harm to Starbucks in retaining the employees who had violated store policy by staying after hours, with all of the pretext considerations that Justices Gorsuch and Sotomayor have referred to. You'd be happy with that, the balance.
Very happy for factor 3, but factor 2 is irreparable harm.
Wait, before you leave factor 3, why is that the irreparable harm factor you're talking about?
Balance of the equities was exactly what Justice Barrett said.
Oh, I see. All right. So irreparable harm. What is being addressed there? I thought it was whether the board's remedial authority would be harmed. That's why they're seeking the preliminary injunction.
Yeah, and that just is empty words without saying what in the harm is irreparable. Always irreparable harm by definition.
But you've said that many times, and you suggest that this is happening all the time. There's record evidence that in the last year the board has sought 14 10J injunctions. So it's not as though this is happening a lot.
Well, totally fair, just when it happens. But in terms of the
right, but what I'm saying is, if we're worried about an abusive board doing things that it's not supposed to be, giving undue deference, it seems like the board is pretty careful when it's determining whether or not to even seek these injunctions, since it's only asked for it 14 times.
Well, I'd like to take that on because I do think that they are relying on the fact that they've done a fair investigation. And no matter how much investigation and how much careful consideration, it's still a litigating position. It's not the fact-finding, the adjudication that Congress has. And third, can't have it both ways. They're spending so much time investigating, maybe they should spend that time adjudicating so you don't need these year-long injunctions. Or if they're saying, well, it takes so long for us to adjudicate, maybe because it's a hard question.
But I guess what I'm saying is they're only saying that in 14 cases. I mean, you're right, maybe they should be going faster, but they have only asked for this kind of injunction in a very, very small number of cases. 20,000 complaints are filed with the board. 700 result in board action. And of those 700 that the board is investigating and doing and determining, they've asked for this kind of injunction 14 times. So, I mean, I appreciate that maybe the standards we need to look at, and I understand 4 factors versus 2 factors, but this is not sounding like a huge problem.
Well, restraint should get. So board only sought 1 injunction. Can you please hold that the 4 factors apply?
And so when you said the normal process, so it's just the traditional 4-factor test applied normally. That's
yes.
what you want.
Yes. I hope I didn't. That's not a trick question.
Yeah, no. It's supposed to be a clarifying question.
Yeah, 4 factors with no deference, and to please make sure.
Maybe I'll take that as a compliment that you think I'm that crafty, but really.
I think we definitely need a reversal with the 4 factors.
And just on the irreparable harm part, you say in your reply brief that under that 4-factor test applied normally, the court is supposed to decide whether delay is going.
Right, as long as it's actually irreparable, like there's some. So let me just see if I can try to be very, help here. Chill can be irreparable, but it has to be chilled from something that's about to happen, an event that can't be unscrambled. And so when we talk about the board's remedial factors, it can't be faith in workplace democracy. It has to be, there's an event, there's an election that they've actually, barricaded the store and employees can't get in to vote. Unless we get this injunction, you can't recreate the conditions. So that's all we're talking about. And there, the board's remedial power is being frustrated, and there's irreparable harm. But all the more reason you've, balance of the equities. It may be that the employer had to shut down the store because it's not making money.
And on the equities and the public interest, I think also in your brief you acknowledged that when a statute like this is involved and public interests are involved, a court is supposed to take that into account in a way that's in private parties. In a case between private parties with only private interests.
I think that's correct, because by definition, the public interest is broader than a breach of contract. And if you have, the environment or voting rights, there's public interest. But the case that this originates, and in the Oakland Cannabis and the Virginia Railway, it's public interest as deliberately expressed in legislation. So where the court has been on public interest is saying district courts can't reach out the confines of the statute either in going too far or too little. And that I think does go to public interest. But I do think our point is, because public interest wasn't even referenced below, except for the district court saying there's a public interest in the statute, is that if there's not a showing under all 3 factors, the public interest is not served by, putting a scarlet letter on an employer and having them just live under injunction that they violated the act based on a non-frivolous legal theory with not even their side of the evidence being heard. That is very damaging to the public interest.
Are you saying that be. It's just that it requires more of a showing than the Sixth Circuit required here.
Yeah, so the Sixth Circuit 3 times said, there's inherent chill, but they also pointed to evidence of chill. And all we're saying is evidence of chill needs to be tied to something that can't be undone, like we can't vote. Now that we're chilled from voting, there's about to be a vote. The court said 2 things here in terms of chill. They said no one was wearing union pins because they were scared. And 2, the terminated employees, although they're on the bargaining unit, it's not as convenient to talk to the fellow employees if you're not on the shift. And those are harms, but they're not harms that are they're not the harms that are irreparable unless you're going to say any time that you have a allegation there's fear of retaliation or an encumbrance, somehow that's not reparable. There was not even a bargaining thing scheduled.
Now all you're
the
doing
union had just won the vote.
Now you're asking us, in the opinion, to right here and said apply the traditional test. Right?
Yeah, I agree. I was just trying to explain to Justice Barrett that we concede that chill could definitely be relevant, but what we're concerned about is the board's definition of chill automatically leads to whenever there's something against unionization effort, that's irreparable harm. But yeah, if I were you, I would leave this a very short opinion, but please make clear that irreparable harm means irreparable.
Can I ask you about likelihood of success in this situation? I know others may have taken it off the table, but I'm a little curious as to why the district court would not at least have to put itself in the shoes of the board when making this predictive judgment. I mean, this is why I said context matters in my view, and that we're in the context of a statute in which Congress has given the board the ability to determine the merits, and at least in the first instance, and the ability to investigation, to find the facts. And in this context, that body has made a preliminary determination in these 14 cases that an injunction is warranted. So is that relevant to the district court's determination, or it just comes in and handles this as though there was no board, or the board is just one of the parties and doesn't pay any attention to those preliminary determinations?
It's totally irrelevant because when the board...
Irrelevant or relevant?
Totally irrelevant because the board is a prosecuting party. It is a party that the NLRB is the general counsel. He's an adversary.
But not according to the statute. The statute, it doesn't just relegate the board to prosecuting party status. The statute says the board is the one that's making the initial merits determination. And so when you're asking in the context of the preliminary injunction, what is the likelihood of success on the merits, it doesn't seem to me to be irrelevant that the board has determined, based on its preliminary investigation, that an injunction is warranted.
Well, it's the general counsel as a separate authority under the statute, but I would be embarrassed if I were the board to say, yeah, we've made up our mind and we hope district courts...
No, it's not that they've made up their mind.
They haven't.
The question is, given this unique statutory context, we have the board as a fact finder and a decision maker and also a prosecutor, as you pointed out, right? That's what makes this context different than when we would ordinarily apply the 4 factors as a court. And we have an authority here that has made a preliminary determination that these facts are such that there's a likelihood of success on the merits. So how can the district court ignore that?
Because what you just said basically sums to a litigation memo that a lawyer wrote to the board, and the board signs off not in its capacity.
Board in its adjudicative powers as the board has not yet determined anything.
And they better not have, because then they're going to look biased. But more importantly, the board, the litigating arm can file this injunction and then turn around and change his or her theory before the ALJ and the board.
I understand, but we're talking about a prediction. And so I would think that the litigating arm of the board would have a pretty good predictive capacity in terms of assessing what the board might do in this case. Well, and I just want to know why that's irrelevant to a district court in this situation, also determining likelihood of success on the merits.
Okay, so if you have a pure legal issue, this is completely irrelevant, because who cares what a lawyer in NLRB thinks? I mean, if there's a meaning of the statute, it just doesn't matter. In terms of this case, which is a question of burden shifting in terms of what caused determination, That is a mixed question of law and
cognizance of the fact that agencies almost always win before their adjudicative bodies.
If they have a 90% success rate, we'll always lose. I mean, really, I can predict, and the board tells courts this, you should know we're going to win because we always win. That's in their manual.
I mean, the fact is the government cites at page 39 of its brief that applying the two-part test, the success rate of the NLRB is only 61%. So it's not a rubber stamp. Even the two-part test is not.
Right, and we're saying that's because in the two-part test, the overwhelming cases settle. And so that takes, the fortitude of those employers that fight on is probably because they have a good case. Except to say
the four-part test was the two-part test, but yet it's fighting the four-part test.
I think the government's view is we'll take the traditional test if you apply it untraditionally.
Consistent with the untraditional context in which we are operating.
Yes, and all I'm trying to say is it's not that untraditional to have an administrative agency. There's a lot of them in the federal government, and the Congress authorizes injunctions a lot. And when it uses terms like just and proper, Congress knows how to, and we cite examples in our brief, to give the agencies a leg up. It does that, or at least in the trademark context, it does in another context where they'll presume irreparable harm. I think in the antitrust context, there's also special concerns. So Congress knows how to do that. But the fact it went to the district court, which is completely outside the normal process of board review, suggests that Congress expected district courts to do what they
completely out of it, and that they just kind of brought them in this one capacity. That's what I had understood.
Yeah, that's correct. That Norris LaGuardia basically put almost an absolute categorical ban on injunctions because courts were too aggressive in stopping unions. And then it shifted in 1947, pro-employers. So it's a little ironic that the government is relying on a statute that was supposed to help employers. But the district court is, supposed to exercise the just and proper discretion. Otherwise, it's banned under the Norris LaGuardia from entering an injunction.
Justice Thomas, Justice Lee, Justice Barrett? No. And Justice Jackson? Okay. Thank you, counsel.
That the inquiry should focus on whether the board is going to be able to remedy the harm at the end of its proceedings. At page 2 of its reply, it now concedes the focus is on the board's remedial power, and I understood my friend to further concede that point in her argument this morning. Second, on harm, the question is not whether there is a certainty of harm. The question is whether there's a likelihood of harm. The test used by the Sixth Circuit is reasonably necessary. That's the Ahern case. We think that's fully consistent with this court's precedents. And as to whether all discharges count, we agree that not all unlawful discharges necessarily show irreparable harm. The question that the board looks at and the question that we think the court should look at is whether that extinguishes the momentum of the union drive or impairs it in such a serious way that an order from the board a year or two down the road won't be able to restart the drive. Not override that judgment in weighing the equities at that stage. This is the Oakland cannabis case. The court says if Congress has made a judgment that something is unlawful, you can't basically make that thing lawful at the equity stage by refusing to enforce Congress's judgment. That doesn't mean that in some cases at the preliminary stage, if there's extremely compelling interest on the other side or public interest on the other side, that an injunction will automatically be necessary. But we think that in a case like this one, where Congress has made a judgment in a run-of-the-mine case, there's only going to be purely private profit motive interests on the other side. injunctive relief is typically going to be warranted. Again, I think petitioner concedes this basic point at page 13 of its reply. It says that courts are not entitled to revise Congress's judgment. Third, that leaves the merits, which I think has been the subject of a lot of discussion this morning. We think that the court should take into account all relevant context. Year, it is 750 complaints. Last year, it authorized 14 petitions and filed 7. That's 7 out of 20,000. We think a court can properly take account of that in trying to make a predictive judgment about how the board is going to come out. This ultimately is a predictive judgment. How is the board going to come out? What is the likelihood of success before the board? And it's relevant that there's substantial winnowing that goes on before the complaint is filed in district court. I think it's also relevant to note that the board has approved the Section 10J petition. And just to clarify the separation of functions within the agency here, the general counsel is the prosecutorial arm of the board. The board members themselves are the adjudicative authority. But the statute, Section 10J itself, vests in the board the power to approve a Section 10J petition. So before a 10J petition is filed in court, the board itself has approved it. And that's relevant in making the predictive judgment about how this claim is likely to come out before the board. The adjudicator has all consideration for the district court to think about in determining whether there's a likelihood of success on the merits.
Counsel, you mentioned that it's a small number of, I forget exactly your framing, that what, reach the question in court about the application of the factors?
Out of the 20,000, there's only 7 that get to court, right? Last year, those were the numbers.
And you said, therefore, we should assume what?
I think what the court should do is just to think about the fact that the board has basically brought the cream of the crop cases before the board. This is before the court. This is an expert agency that has said, we think these are the most deserving of relief. And as Justice Jackson was mentioning earlier, this isn't in a case where the board is engaged in abuse or bringing all sorts of claims before courts. It's
I don't know why
the
inference is the exact opposite, that these are the ones you really feel that you've got to put, the best behind them, because these are the ones that are going to
is worried about irreparable harm accruing before the board can issue its decision.
Mr. Rayner, I'm a little curious about your statistical argument. So let's say that that your office files a motion for emergency relief, and you want to try to convince us that there's a probability that we're going to grant certiorari. If you, in making that argument, you say, look, we're very selective in the Solicitor General's office about when we're going to petition for certiorari. We get lots of requests from the litigating divisions to file cert petitions, and we go along with that in a tiny minority of the cases. And we have quite a good record of success when we do petition for cert. Is that something we should consider in that context?
Justice Alito, I don't think there's any bar to the court considering it. And just, if I may.
Seriously?
And that Congress
I think you're going to have to tell me why it's different.
The reason is that Congress has set up a scheme where the agency can seek 10J relief to protect its own adjudicative authority. And as Justice Jackson mentioned, the history here is that initially there was pretty widespread judicial intrusion into labor disputes. And in 1932, Congress cut that off and said we're not going to allow district courts to intervene. And in 1935, it centralized adjudication of disputes in the board. In 1947, it decided it had to walk back its restriction a little bit, and so it allowed Section 10J relief. But it didn't allow Section 10J relief for district courts to engage in a wide-ranging and intrusive involvement in labor disputes. It allowed courts to come in basically as ancillary to the agency proceedings and protect the integrity of those proceedings. And in that context, I do think it is relevant that the board is selective about the petitions that it files.
I appreciate that point, but would you agree that the likelihood of success on the merits inquiry opposed to other cases?
Correct. It's a focus on this particular case.
It has to be focused, and so we have to look at the merits of this case, right?
Correct.
And so the Sixth Circuit's rule that you can't engage in fact-finding has to be wrong.
Justice Gorsuch, we agree that some fact-finding is permissible, and I think there's been a tendency to caricature what the Sixth Circuit is doing. There was a 2-day evidentiary hearing in this case, and there was discovery.
Well, the Sixth Circuit said fact-finding is inappropriate.
Correct. It did say that, and I agree that language, if taken out of context, could be read in that way.
Okay, so that's wrong.
I agree that statement on its own isn't.
Yeah, and you've walked through the 4 factors, which seems to suggest you agree there are indeed 4 factors.
We agree that all 4 considerations from Winter are relevant to this analysis.
Do we apply the test the same way we usually apply it as a general matter?
I think
does the district court apply it the same way as?
I think there has to be some translation to this context, and on just focusing on likelihood of the
that doesn't sound like
It doesn't sound like likelihood of success on the merits at all.
It's likelihood of success on the merits in the sense that you're assessing how likely is the board to succeed, and we think they have to show a reasonable probability of success. That's the standard that we think governs here, and we think that's consistent with.
Not likelihood of success reasonable? What's reasonable? What is that? It's obviously, is that above 50%? Is that 30%?
I'm hesitant to put a percentage on it, Justice Gorsuch.
I'm not surprised.
It's lower than 50.
I think it's consistent. For example, Justice Kavanaugh, your opinion in Labrador says fair prospect. I think that's generally along the lines of what we have in mind. We don't think reasonable probability necessarily needs a percentage to spell it out.
So I'm sorry, are you saying it's the same or it's a lower bar than the usual likelihood of success standard as applied in courts every day under Winter?
We think that it is a lower standard, principally for the factual part, which I mentioned, which is we think if a point you to Osborne-Hesse, which is a decision where the Sixth Circuit says, look, the board has put in evidence that this.
And is the reason for this lower standard only that the board is, generally restrained in asking for these along the lines that you said, or is there some other reason why courts should apply a lower standard?
I think it's a structural point, which is that Congress intended the board to be the primary adjudicator here.
Well, it did intend the board to be the primary adjudicator, but it also gave this power over injunctions to the court.
I think that power has to be exercised cognizant of the fact that the board is going to be adjudicating.
I don't see why that follows, because it's a preliminary analysis. It's just a quick look. And what happens in the merits happens at the merits. And in all sorts of alphabet soup agencies, we don't do this. The district courts apply the likelihood of success test. Others.
Justice Gorsuch, with respect to the statutes that they identify, the case law in the lower courts does not uniformly support them. It's actually quite mixed. There's a lot of it that supports our position.
There's a lot on the other side, too.
I acknowledge that it is.
An awful lot. And I just struggle to understand what you're asking lower courts to do and how it would be unique to the NLRB context as opposed to others. Cognizant as well that these injunctions often run against employers and for the benefit of unions, too. So whatever standard we come up with here.
To the extent you adopt a standard in this case, its generalizability will actually be fairly limited. There's only a handful of statutes they identify that allow injunctive relief pending administrative proceedings. There's 3 in particular, the FTC, the EEOC, the Department of Labor. But other statutes, for example, simply involving the federal government, the authority to seek.
What we're here is a predictive judgment related to what the board is likely to find. That there are predictive judgments, or there's the preliminary relief determination that courts are used to making, which is who's going to win, from my perspective, as between the parties that are before me, right? Someone's brought a complaint, someone is defending. I'm looking at this preliminarily and making a judgment as to who's likely to win on the main issue that they have brought. Course of things. I think, and maybe I'm wrong, and that the predictive judgment here is not that. The predictive judgment here is the board is seeking injunctive relief to protect its remedial authority, And what, to the extent we're applying, it's the likelihood that the board is going to decide that there is an unfair labor practice in this situation and reverse the stakes on the ground or whatever. Is that right?
Yes, I do think that's correct. The board is the principal adjudicator here. We're trying to predict how they're going to come out.
I don't see how that could possibly be, Mr. Rayner, that, a court is supposed to say, well, I have one view of the law, but I'm just going to assume that the board has a different view of the law just because this...
No, I took the...
It's got to be the court's view of the law, right?
Well, I took the premise of Justice Jackson's question to be, for example, if there's NLRB precedent that the court hasn't weighed in on.
Yes, sure. If there's an NLRB precedent that, that's the governing law, the court is supposed to think about that.
Correct.
Because that's the governing law.
Correct.
But it's just supposed to think about that as a court doing what courts normally do, which is applying the law as the court finds to a case.
Yes, Justice Kagan, and if you all were inclined to think that the likelihood of success test applies exactly the same way in this case that it does in others, I still would submit that it would be easier for the board to satisfy that test, principally because, as I mentioned earlier, the board has already approved the petition. It has signaled its preliminary view of the merits.
But that means we're giving the board a boost because of the screening function that it's engaged in. And we're saying, well, the board clearly thought it was meritorious when it had its prosecutorial hat on. So we should assume that when the board has its adjudicatory hat on, that it's going to rule in favor of itself.
Justice Barrett, the evidence before it, the ALJ hearing evidence, for example, at the time it approves the petition. But I would dispute the notion that it's acting in a prosecutorial role at this stage. It's approving the petition, the 10J petition, to protect its adjudicative authority. And Congress hasn't given it, for example, the way that district courts have the authority to issue a PI to protect.
District court is an independent check, right? Because this is a big deal to have
Correct.
The injunction in place, no matter who it enjoins. So the district court is an independent check. So it seems like it should be just doing what district courts do since it was given the authority to do it.
Yes, we acknowledge this isn't a rubber stamp, and I think the success statistics in the various circuits bear that out. And we do think that there has to be an inquiry into the merits. Osborne-Hesse, again, is an example where the court said the evidence is overwhelmingly against the board. We're not going to blind ourselves to that. We're not going to grant relief here. There is some factual weighing that goes on. We're not disputing that it is a check. The only
this way. So the district court's supposed to ask likelihood of success on the merits. Is it supposed to ask what I think of the likelihood of success on the merits? Objectively, as best I can come up with, as neutral a judgment as I can muster? Or is it supposed to ask, well, I don't think you're likely to succeed, but I think that seems to me the delta between the positions here. And, it's clear to me that your friend's going to win, but the board's going to rule otherwise. Is that really supposed to be what a district judge is supposed to do?
Well, Justice Gorsuch, I'm not sure, I guess, in that hypothetical, what would be the basis for the discrepancy?
Nor would I, except for maybe the statistics you keep referencing. The fact that boards tend to win in front of boards. They sometimes lose in later review, but they win at least in front of the board. And I guess if we're going to take account of statistics, why not also ask reversed? Where does it end? And why, again, shouldn't a district judge just ask, as best they can muster, with relevant NLRB precedent in mind, all of the law, all of the facts, and it may have different facts before it, too, than the board did when it authorized the 10J. It's going to hold a hearing, right. So it's going to be a different factual magistrate can issue.
Justice Gorsuch, setting aside our frontline position about how we think it's a lower standard here, if you thought it was the same standard, then our position is simply that all contexts should be considered. We're not contending that any one particular characteristic should be dispositive. Ours is the pro-context position.
But why? So why do you think it's a lower standard?
Justice Jackson, again, I think it's a couple things, but it's principally structural. We think the board is the adjudicator here. The role of the district court is to protect and facilitate the board's adjudication.
And that's in the statute it's not your view of just sort of how it should be.
Correct. Yes, exactly. This is the function of a Section 10J petition. The 10J petition expires when the board issues its order. At that point, there's a different statutory authority that allows the board to enforce its order in court. And so all we're talking about is a petition that's specifically designed to protect the board's adjudication. And again, the historical record supports this in the sense that it wanted to give a limited protect to the board's adjudicative authority.
Why do you think Congress did that?
I think the reason is that in 1932, when it passed the Norris-LaGuardia Act, it imposed very stringent restrictions on district court ability to issue injunctions. And in the post-war period, there was essentially a lot of labor unrest that courts weren't able to step in expeditiously and stop, and the court thought that was necessary. And so if you look at the legislative history, Congress says, look, it sometimes takes the board a while to rule, and there might be a lot of harm inflicted in the meantime, so we need to give district courts the authority to prevent that harm while board proceedings are ongoing.
To resuscitate the labor injunction and Debs, right?
Correct.
And that was not a particularly glorious era for courts. And you would think, therefore, maybe a more restrictive injunctive test rather than a looser one. Traditionally, you might want them.
I would frame it actually a little differently. I think what Congress was concerned about doing was restricting the power of district courts in protecting the centralized adjudicative authority of the board. And in restricting the power of district courts, you'd maybe want the full considerations of equity brought to bear rather than a looser standard that results in more judicial interference in labor affairs. I recognize that that's one way to think about it, but our view is that ours is actually a more modest conception of the judicial role, which is that it's protecting the board's adjudicative authority rather than engaging in its own free-ranging exploration of the merits.
We're talking about here. It's not sort of protecting the parties in general, it's protecting this particular interest, which is the board's authority.
Exactly, and there's we are not suing on behalf of any private parties. The board is suing to protect public rights only, and we do think to the extent this is generalizable, it's actually statutes to which our rules apply. The court has no further questions.
Thank you, counsel. Do you agree with your friend on the other side that we can dispose of this in a short opinion?
Yeah.
Thank you. Justice Thomas.
Mr. Rayner, if the approach here is to protect the interests of the board, do other agencies benefit from this approach? And if they don't, why?
Justice Thomas, as I acknowledged earlier, I think other agencies that have a specific statutory authority to seek adjunctive relief pending agency proceedings, I think that the listing here would apply to all the statutes that they cite, where, for example, the government simply has the ability to sue to enforce federal law. That doesn't have the same type of ancillary quality that we think the injunctive relief in this case does.
Justice Alito? Justice Sotomayor?
The ALJ rule, how long is this going to take?
The statistics are that typically from complaint to final board order is about 2 years. It varies somewhat every fiscal year, but about 2 years. So we're coming up on when you might expect the board to rule on that basis. The complaint.
And the injunction lasts till then, or lasts till what?
It lasts until the board issues its order. At that point, there's a different statutory authority in 10E where the board can go get preliminary relief.
Are we sure that before we rule, the board isn't going to have issued its preliminary injunction so that this case is mooted?
I'm not sure about that. I'm not privy to what the board's time. If it were to rule, before this court were to rule, I think that there would be a question of mootness because the petition would expire, the injunction would expire by its own terms.
That's what I was asking. Thank you.
And we would obviously make a submission on that point if that were to occur.
Justice Kagan?
I just want to make sure I completely understand how you think this case is narrowed. You start Ms. Blatt's reply brief as to irreparable harm, as to the equities and the public interest. that I take it that you, and I don't think that Ms. Blatt at all retreated from her reply brief today, so I take it that that's pretty much not at issue now, and that the real question and dispute is whether the likelihood of success inquiry is ratcheted down somewhat. Is that what you understand the only issue in dispute to be?
I think so, Justice Kagan, assuming that the way we understand irreparable harm is that it focuses on the board's remedial authority and there only has to be our view is simply that Congress has said what the public interest here is. If you think there's been a likelihood of success on the violation, however you want to define that, by the time we get to public interest and weighing of the equities, it's going to have to be a pretty compelling private interest on the other side to overcome Congress's judgment that this kind of conduct should be illegal.
I understand the court is supposed to say, well, let's pretend I'm not a court. Let's pretend that I'm the board. A court is supposed to do what a court does. Is that correct?
Yes, Justice Kagan.
Look at the law and make the best decision on the law. Now, you have a different standard that you think that the court ought to apply when the court looks at the law and makes the best decision on the law, and I understand that difference. But this isn't something where you're saying, like, the court is supposed to pretend to be the board.
Justice Kagan, I think that's generally correct with a caveat. We do think it's relevant that the board has approved the petition, and we do think in circumstances where there may be a law or a rule that applies account, for example, NLRB precedent.
Okay, thank you.
Just one thing on irreparable harm. You just said reasonably likely, and I think they say likelihood. Those the same things?
Yes, I know. I think basically what we think it has to be reasonably necessary. I don't think there's a whole daylight between those different formulations.
Thank you.
Justice Barrett. Justice Jackson?
One final thing. Why is it relevant in this context that the board has approved the petition when it wouldn't be in an ordinary scenario of the court just making the kind of determination that Justice Kagan put forward?
Justice Jackson, in a normal scenario, the court itself is determining whether to issue a preliminary injunction. So it doesn't have reference to another actor that may or may not have approved preliminary relief. In this case, we know the board is the ultimate adjudicator, and we know that it has signaled relationship isn't present when the district court is issuing the preliminary injunction without regard to an agency request. I don't want to overstate this point. As I've mentioned, the board can change its mind once it hears the evidence. It hasn't prejudged, but we do think this is relevant to the predictive inquiry about how this case is going to come out, what the Thank you.
Rebuttal.
Thank you. May it please the court. Just a couple things. On page 91 of the district court said, in terms of likelihood of success, my next inquiry focuses on whether there are any facts supporting each allegation without resolving conflicting evidence. So there's no question there was none of that. And in terms of the standard that as long as reasonable facts support the board's theory, that should be enough. If that sounds familiar, it's because it's the standard for summary judgment, and that obviously is not the standard for an injunction. And it's a little bit ironic. Judgment, at least get a trial. So this is even worse than a party would have at summary judgment. So they should have to prove their case like any other party. In terms of so the likelihood of success, just another thing to keep in mind, the only evidence that the district court is going to have is the evidence before the district court. In terms of the legal theory, some of its legal theories, including in a case where Starbucks sought discovery, the board turned around and called that an unfair labor practice and then told the district court they had to defer to it. The board also says that you have to bargain with unions that have been decertified. So these are very serious legal questions that do come up. And the other thing, if they want deference onto their investigative decision, then why aren't they producing their litigation memo? I mean, really? That's what you're supposed to do when you get deference, is show your work. And this is obviously a privileged document, and their manual is a cookie cutter thing saying, here's how you get your litigation memo, here's how you get board approval. obviously, the district court's findings aren't binding on the ALJ or the board. And in terms of the lower courts, the only thing I'll add is that almost all the cases that kind of watered down the standard are pre-winter. There was one post-winter case that didn't cite winter, and then the Ninth Circuit the government relied on and cited, the court said be reversed.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.
I am. I have my stick mic up because there might be a spokesman showing up, but yeah. Thank you. Bye-bye.
I've been watching it for a minute. I gotta go to hours. I'm planning on making run over at 4.3. Japan.
Assalamu alaikum wa rahmatullahi wa barakatuh. Peace and blessings to you all. Sabah al-khair. Good morning, everybody. We've now made it through day one of our Gaza Solidarity Encampment. First speaker for the day, we've brought on Mrs. Brooke, Dr. Brooke Love. Yeah, but she's here. She's going to be speaking on feminism and anti-Zionism. So, alhamdulillah, I'll be passing on the mic to her, and I'll let her steal the show.
Hey y'all, I don't really have a show. I have a little class. And the way that circulating in feminist struggles in this moment. You're welcome to just come and hang out here. Ideally, I'd love to just like sit in a circle. Feel unafraid by reading a quote from Lina Mayari, a Palestinian feminist. She's a scholar of resistance. She's a resistance studies feminist scholar, and her work is specifically an investigation of sumud, which is often translated to steadfastness. You might think about it more broadly as resistance, or she sometimes calls it refusal to surrender. So she studies conditions of webinar with her with the group Feminists for Justice in and for Palestine on March 8th. March 8th being International Women's Day, a really important day for feminists all over the world. And this is one of the, I'm just going to read Gender and Women's Studies at Birzeit University in the West Bank, and a scholar of resistance. And so she said, for Palestinian feminists, feminism entails building an alternative, emancipatory, and just world, a decolonial world in which all human beings live with freedom and dignity. In our current world, in which atrocities prevail, building a just world entails the struggle against all intersecting forms of oppression, exploitation, and since forms of power are intersected, our resistance should simultaneously confront all these intersected forms. Amidst the continuous Israeli eliminatory project, Palestinians have resisted and continue to resist in all forms. In the resistance and persistence of the Palestinian people. They sustain their families and communities. They bear the burden when their sons and husbands are murdered or imprisoned. They themselves practice sumud when arrested and in prison. Palestinian women, as their whole people, are the victims of the harsh, aggressive Israeli settler colonial project. Yet it's important to note that they are not humanitarian cases as portrayed by aid organizations. Palestinian women are political actors that struggle to decolonize their lives and communities and build a free and just future. Palestinian women demand politically radical solidarity That was Lena Mayardi's statement from March 8th this year, and I thought that it gave us a lot to think about as feminists, because she's actually asking what feminists around the world, across the globe, might do, right, to actually be a part of and support Palestinian feminisms. And she's saying that Palestinian women demand politically radical solidarity from revolutionary feminists. And I thought about the ways that so many you know, for a long time as a scholar of Jewish anti-Zionism and as a Jewish feminist myself, I've asked, what is Jewish feminism? And could it meet what's being dismantling all repression everywhere? And so I wrote a little presentation kind of exploring different aspects of this question by thinking about current circulations of Jewish identity, of feminism, and of Zionism, especially in the context of U.S. feminisms. So I'm happy to share some of that with you all now, but I want to see if we can pass the mic around and just ask folks, and I would even encourage you to come a little closer because are definitions of feminist solidarity, you know, and this isn't the only time that we are presented with a crisis, right, of oppression. So, you know, abolition feminists focus on maybe solidarity with people who experience gender violence. The settler violence, right, that results in the subjection of indigenous peoples, and we think about what feminist solidarity might look like in a decolonizing frame, right? There are all these forms of feminist solidarity, and there are all these ways to focus on particular crises. And so I guess that's kind of my question is like, what do you think of when you think of feminist solidarity? And it could be an example of something that you've seen in the last 6 months. It could be an example of something. In your name and your pronoun, you can. I'm Brooke Lober, and can I pass it to you to share with us a thought on feminist solidarity?
I'm not good at words right now. I'm really not good at words right now. I only slept 1 hour. say.
I think, to me, feminist solidarity would just be standing. I think looking at everything intersectionally and standing with the notion that it's all inherently connected, no matter who you are, where you come from, what the place you're at is.
To talk about this, but I feel that solidarity, like you said, is something that's like all connected, and being selective is the antithesis of what solidarity is. So when it comes to feminist solidarity and solidarity with other sorts of intersectional kind of all of that, like, especially in terms of like settler colonialism, that these things don't happen in isolated incidents. And what we do for one is a win for all, I think. And being aware of our positionality, I think, is really important. So for me, for example, as a male, thinking about how I could be a better comrade, and always checking, like, you know, how I could be more aware and like what I can do to support in any way.
That was beautiful, and thank you for opening up. Just picking back on that, you know, ready to serve the group and the collective however is needed, right? Sometimes we're not all doing it the same way, but when we just remind ourselves of the collective goal, or, you know, for example, today I don't have all the answers or know all the history, but I know enough to know why I'm here and why I'm here to support my peers. So sometimes reminding our we all show up differently. Some of us are going to be here, some of us are holding it down at home, and, you know, educating and talking to children. And so again, just playing that little piece and reminding ourselves that every little piece does matter.
Yeah, wow. I want to echo what everybody else has already said. I think that a lot of beautiful words were already spoken, and for me, I do think that we need to approach everything from a feminist angle, from an intersectional lens that is expansive. And being able to I don't know. I might need to circle back, just because it's a big broad question that I have a lot of answers to, and also no answers whatsoever.
I'm not playing against Cristiano,
Yeah.
Hi, I'm so grateful. Thank you for hosting this talk. Just to echo a lot of the other sentiments, positionality, want to recognize the power of solidarity. For the past few years, I was organizing in a defense campaign for a woman named Wendy Howard, who is based in Tehachapi, California. She defended herself against her abuser in 2019, and in the process shot him, and he died. And they wanted to put her away for life because they tend not to recognize self-defense as a right of women. And so we organized around her for the past few years. It was a huge learning experience for me. It went to trial last year, October of 2022. And she was acquitted of almost all charges. It was a hung jury for bond. So she went home. She's on probation for a year, which actually ends soon in May. They considered it time served, 100 days in jail, and it was just so, the amount of solidarity, the amount I learned through feminist scholars. We worked with some different organizations, Survived and Punished, who advocate exclusively I was just really, it was just so energizing and heartwarming to see how people showed up for fundraising to pay legal fees, how people showed up at rallies, at protests, just leaving positive comments online. And I think that as well, it's so heartening to see how people are showing up across genders, across the spectrum of everybody that has showed up here. And the rally yesterday was very much feminist-led, which I really appreciated. I really love all the powerful women, powerful Palestinian way. And so looking back as well at, feminist-led movements, the civil war in Liberia, that was really powerfully Greenbelt movement led so much opposition to authoritarian leadership in Kenya, and I think it just really grounds the fact that change is so possible, and we learn so much through feminist leadership, and I'm so grateful to continue to learn more and for these spaces.
Thank you for all of your words and for holding this space. I'm very grateful to be able to be a part of this and to be able to see all of the bodies that are a part of this movement. I think feminist solidarity to me is the recognition of the intersection of all of our collective identities on this very community, localized level, and recognizing how that solidarity has global, expansive impacts, and also our role in of a very real institution and legacy, and holding spaces like this is, I think, a step in creating solidarity transnationally, but also meeting people on their levels and meeting people where they're at. So thank you.
Thank you, and thank you to everybody who shared. I think I resonate very deeply with a lot of what has been said. I think I heard over here you said forgiving, and that was something that I really resonated with, but at the same time, coming into this forgiving, but also diligent in our grounding of humanity in everything that we do. I think it's really important to step into these spaces with humility and act with the understanding that we don't have all of the knowledge that we might desire, but that collectively we can come together and form that knowledge and form that and find power in those spaces that we create together. So I'm really grateful to be in one of those spaces with you all today. Thank you.
Yeah, I appreciate a lot of what has been said. For me, what I really want to center when I'm thinking about my understanding of feminism is just expanding my empathy to those who the systems in place in our society want to take away the personhood of, and recognizing that personhood and acting in accordance with that personhood as something to be cherished and protected. So yeah.
Thanks, everyone. Or might be, or some examples. I think there's a couple of you that didn't get to weigh in on this yet. Should I pass you the mic?
Hey, so I think that
solidarity in a feminist context and in most other contexts is there's a lot to say about it, but also a dimension that I find really essential is material solidarity. I think that there's a lot of I think, like, especially in a neoliberal context, there's a lot of metaphor and there's a lot of gesturing at solidarity and liberatory practices, but there's not a lot of material action and any sort that create systems of oppression. And I think that's especially true when we're looking at feminism, especially with a decolonial perspective, because the machinery that upholds colonialism, and I think that's the same with Zionism. And I think that in this particular movement, a question I find myself asking is, how do I show up in a way that is material? I don't really know fully what that ends up looking like, but I think that it's like an important question that I try to center when I try to think about solidarity is what ways are gestural and which ways are material and actually beneficial.
Thank you. One more thought on feminist solidarity over here.
Thank you. I'm not as knowledgeable. But my thoughts are that women and femmes are at the liberation struggle. If we were talking about like Black Lives Matter here, or in context where my family's from the Philippines, we have a lot of celebrated heroines in our history, in fighting for liberation and, you know, all the struggles abroad. I've been reading a book about the events leading to the first Intifada, and like there's a lot of women's organizations trying to expand people's consciousness and getting people organized, and job as allies of that struggle. And if we want to be a good struggle, if we want to be a good ally to the women and femmes leading that struggle, we need to support them materially too. And yeah, that's what I have. Thank you.
Yeah, thank you all. I mean, I don't think we can create necessarily a synthesis of what everybody said, but there's some themes that we all kind of pointed towards, right? Struggles of the global south, women's leadership in those struggles often, and kind of this critique of neoliberal feminism, which doesn't seem to reach like the material inequalities that are inherent to capitalism, especially on a global scale, but even on a local. Very odd to say, you know, these kinds of separations that we've taken as common sense between different struggles. We so completely believe commonly that feminism only couldn't see that a demand from indigenous communities like land back, which would obviously benefit Native women, so obviously and so clearly, and the survival of indigenous people, whole cloth, right? It's hard for us to even say that that's a feminist struggle or why that would be a feminist struggle, because our feminism is so removed in the United States, kind of mainstream and at this point neoliberal capitalist feminisms are so removed from those collective people's struggles for survival and thriving and self-determination and liberation, right? But if we change our lens to some extent and we actually put those that's looking at genealogies of Black, Indigenous, and migrant or borderlands feminisms, you know, under the U.S. state, often contesting the power of the U.S. state, or whether we look on a global scale, I mean, we do actually see that the mass mobilizations of feminist struggle are generally not at this point in the United States. And when they are, which is rare, but we can talk about a couple of examples of what people have done to attempt to produce mass feminist struggle here in the United States. You know, they're often co-opted and demobilized by those very same forces of capital that they operate within, right? So. And neoliberalism, even moving toward feminism's whole cloth. So they present themselves as feminists, but they actually go about destroying feminist struggle. I don't think that that is necessarily the most inspiring conversation. So I would be happy to move towards some feminist legacies that are discounted and are disposed of, that I hope that we can also work to recognize and revive. But I can start with a little bit on that. Can I share my critique with you all a little bit? So I have pieces of paper because we don't have a projector, and I'm pretty. Of this organism called Zioness. Has anybody heard of it? That's great. Sorry, I'm exposing you to this fresh hell. But recently on this campus there was a visit to Hillel by this woman, Amanda Berman, and she's, I think, the executive director of the organization Zioness. So you should already be getting your ears pricked up, executive director of what? What is feminism, a nonprofit project? Is that what we're doing out here? This organization is what I would call an AstroTurf organization. That means it doesn't have that many people in it, but it has a lot of funding and it has a lot of standing. It has kind of an official status. It's called Zioness, and it was incubated is the name that they use for it, by the law. Activists who are students, who are Muslim ethnicity spurs program at San Francisco State University by vilifying it, and this is an organization called Zioness, and it's called, what their tagline is, unabashedly progressive, unapologetically Zionist, and you can go ahead and look them up online if you feel like it. But they present themselves as if they are a feminist Zionist organization. They actually were founded in response to Linda Sarsour's declaration that you can't be a Zionist and a feminist. That's what inspired the creation of this nonprofit organization. And they went on to systematically campaign to destroy also kind of working in legislative and electoral realms, and it made them in many that accused them cynically of anti-Semitism, based on hearsay, based on some remarks, but certainly not based on the deep solidarity across Muslim and Jewish constituencies that Linda Sarsour and some of her colleagues and comrades have invested in. So I'll pass this around. It's really just a graphic, but it's just so that you can see. Please. No, let's talk. AstroTurf. Oh, AstroTurf is like a little bit of a joke, just to pass it around the circle, just so you can see the organizations that I'm talking about in case you feel like looking them up later. The joke of AstroTurf is that it's not grassroots. It's like grass, but it doesn't have any roots underneath it. It's just like march, and they brought paraded on the flag, and then when they were actually this is a story that comes from I think 2017. So really, when they were in the midst of their anti-women's march campaign, they did this anti-Dyke March action, knowing that the Dyke March had been declared an anti-Zionist and Palestine solidarity space. They started changing the words of the chant from Palestine to Mexico, all the walls have got to go, to from everywhere to Mexico, all the walls have got to go. Of course people notice this stuff, and so they argued about it. But I think I want to just question, what is a feminist organization that was specifically created to attack left together and maybe share our criticisms and come to a new synthesis, which I think is a feminist act, more like a political act on feminist solidarity. So I'm a little bit sort of introducing this moment with that, and that Hillel, coming to Hillel at UC Berkeley, that just happened that just happened like last week. So they're on this college tour. Okay, now I'm going to go into a little bit of feminist history. So let me see what I'm going to talk about here. Sorry, you guys, I have too many papers. Give me 1 minute. Maybe one would be too many. Maybe one would be too many, right? Because, every person is a whole life and a whole world, right? There's always debates about numbers in political catastrophes and in genocides. There's always debates about numbers. People don't agree. There's a longer term, because even before October 7th, 2023 was the deadliest year for Palestinian people. I don't know what to say about numbers except, I'm sure a lot of you have heard of the poet Rafat Al-Arir, who had this organization teaching young people called We Are Not Numbers. And I think that the point of saying we are not numbers is that numbers are always an abstraction of people's real lives, right? So we talk about these numbers, and the Euromed Human Rights Monitor is a different organization that's also doing counting. They're a human rights organization with people on the ground in Gaza, and their numbers are much higher because they're also noting the numbers of people who their bodies have not been found, and so they haven't been counted yet. But there is definitely a dispute about numbers. A form of Zionist feminism has arisen in recent years to destroy feminist solidarity. In white-dominated liberal U.S. feminist formations, And it's really a mergingism with U.S. imperial and liberal feminism that happened in the second wave. People call it the second wave because the first wave of feminism in the U.S. and really on a transnational scale was at the early part of the 20th century, early 1900s, things like voting rights and the abolition of enslavement. Other kinds of cultural movements arose that were run by women. We often call that a first wave of contemporary feminisms, although I'm not sure that's the best way to know them. But the second wave, or the feminist revolution that was happening in the starting in in the midst of that, there was a sort of operation of power where a form of white-dominated liberal feminism participated vivaciously in this and sometimes imported Zionist kind of political operations into feminist networks themselves. So that has been something that I've tried to investigate a little bit. And how many of y'all have heard of Betty Friedan? Well, that's too bad. But no, I'm kidding. So, we move on from Zionists, go a little bit back in time to Betty Friedan. Those of you who have heard of her, what do you associate with Betty Friedan? Anything? Feminine mystique? Okay. So, feminine mystique. Having a realization that life is more than Prince Charming, that you've been waiting for this it's kind of similar to the Barbie movie. Like, Barbie has realizations, and that must be feminism. I actually enjoy aspects of that, but just saying. Having realizations about that life isn't merely romance, and it's not just the Prince Charming that's going to come and save you, that it's other stuff too, and that maybe you want to be in the workplace, you want to have a career, you want to be empowered. It's liberal feminism, right? And that doesn't mean that those things aren't meaningful or enjoyable, but if the cycle is the empowerment of an individual woman to rise in success in her workplace, and to transcend the kinds of expectations of marriage, that limits feminist struggle to a particular sphere, right? It individualizes it, kind of makes it into a middle class project, because most women in the world actually do just of workplace exploitation, but rather just says, well, individual women who fight for themselves can rise up the ladder. Capital. Betty Friedan is associated with this, but I want to say a little bit more about her, which is, I think, less referenced, but starting to be more so as more of us do these kinds of critiques. So I'm going to pass around another piece of paper, and it's about what was happening in 1975. So in 1975, really all over the world, anti-colonial struggles were mobilizing en masse, and women were participating in that. Women were participating vivaciously around the world in anti-colonial and anti-imperialist and anti-racist struggles. And from the kind of revolutionary moment of of Algeria, the student movements here in the United States, and there were gender struggles and there were feminist struggles within all of those. And we're actually in struggle, and maybe we're seeing it happen. People go into radical social movements, and when we get there, we realize that we have more to work on than what we initially thought. And sometimes that's the equalities among us. Sometimes that's about gender equities, and I think maybe removing the constraints of traditional gender is one of those projects. So in 1975, there was a call for the World Conference of the International Women's Year. It was called by the UN. And the International Women's Year ended up inaugurating the UN's Decade for Women. So in 1975, in 1980, and in 1985, there were conferences for women, international conferences. And the
existent way to review these decisions.
To the extent that Trump against Hawaii addressed this, it assumed without deciding that consular non-reviewability existed, and it said that it quoted with approval Justice Kennedy's approach in Dinh of saying that a statutory citation would be enough in this context. I think Trump against Hawaii
I mean,
involved
Trump says it's enough. But Trump also suggests that that's the right inquiry. In other words, that we should undertake a Mandel inquiry, and then Trump v. Hawaii says, as Justice Kennedy said in Dinh, that the statutory citation was sufficient. And we can go on to that question. But I was just sort of focusing on the first issue, which is the combination of Mandel and Trump suggests that your first, most dramatic, strongest position have a kind of judicial review, although a very limited one.
I think you have engaged in limited judicial review in a handful of cases without saying that that was required. And there's still nobody who has identified what the cause of action is here or why this would be permissible. Every time the court says this, it says, well, even assuming you can get review, the government has said enough here. And so we do think we would satisfy that standard, and I'm happy to go on and talk about whether we satisfy the standard here, even though we're relying on a different statute, as Justice Sotomayor pointed out, than was at issue in Dinh.
Well, I think the reason that, I don't know, but I can't ascribe reasons to prior courts, but they move fairly quickly to, move on to it, and as long as it leads to the same result, they don't have to struggle with the far more difficult question. So why isn't that the way we should be looking at this, which is as be an easier question from the point of view of the court in terms of the significance of the constitutional question. And so going on to the second question, how would you go about weighing, which may have shed some light on the first one, how would you go about weighing the interest in marriage with the interest in national security? Well, that's like apples and giraffes.
Well, I think the point of Mandel, if we're in the second question, is that you don't do weighing. That's exactly what the court said in Mandel, is that we are not balancing the strength of the government's interest against the constitutional right at issue. It says we're not going to test or look behind the reason or balance it. That's the last paragraph of Mandel. And I understand the temptation to say we should decide the easy question here because the government actually did give more information in this case. But that would still